Okay, I think we might start. Richard Antill's going to speak now. Please give him a welcome.
Thanks, Robert. I'm going to talk about the PPS mainly and how it applies in this the scenario of the uncollected goods, but also probably a bit more generally about the PPS. To start with, I just thought I'd mention a few useful resources that it's worth knowing about. As Robert said in my introduction, I spent a couple of years at the LPLC and authored a few bulletins that you might have seen. And I've noticed that the LPLC have actually issued some more bulletins. They're on their website. In particular, a bulletin on land leases and the PPS Act, so dealing a little bit with uncollected goods but also other issues. The sale of land and the PPS, so looking at the issues around PPS and conveyancing transactions. So if you're interested in that, have a look at that bulletin. And the sale of a business in the PPS Act. Obviously, the PPS has a big impact in the sale of a business, so you might want to have a look at that bulletin as well. I'm not the author, so I don't claim any credit to those bulletins, and also therefore don't have any responsibility. And I've just extracted in my my short summary a quote from one of those bulletins where it says, "Practitioners for both landlords and tenants need to understand the Personal Property Securities Act may apply to the lease of premises because," and the four examples they give, that a landlord of premises may also lease goods to the tenant, so shelving or some sort of fit out of the shop that if it's not actually a fixture to the land, is actually a lease of goods, and if it's a lease of goods for more than 1 year, then it's a PPS lease. It's caught by the PPS Act, and therefore the landlord, even though they are the owner of those goods, is a secured party, and to protect their interest should register or could register that security interest. The second example they give is the landlord may obtain a cash security deposit from the tenant. Third, a landlord might provide a lease incentive to pay for the tenant's fit out on the basis that the fit out will then belong to the landlord at the end of the lease. Again, if they're not fixtures, that will be caught by the PPS and therefore be a security interest. And then the fourth example is when a tenant vacates premises, the goods may be abandoned. So have a look at that bulletin for dealing with all of those issues. The other thing to note as well, if you're not already aware of it, is in August of this year, the Law Institute, the Leases Committee of the Law Institute, issued a PPS Act clause to go into their standard commercial lease, and it's available on the Law Institute website. So it's just an extra clause that deals with some of the PPS aspects, essentially that the landlord can register a security interest, that the tenant must give their details in order for the landlord to register security interest and so forth. So if you're dealing with commercial leases, that's probably something worthwhile having a look at. But I suppose putting aside the technicalities and whether something's a security interest or not, why should a landlord register a security interest? And the first point I'd make would be that it's really worthwhile to register a security interest, if only to avoid a fight with the tenant's liquidator. If your tenant goes into liquidation, you don't want to have a fight with the tenant's liquidator about whether something's a fixture or not. And I think it's worthwhile really looking at life through an insolvency practitioner or from a liquidator's point of view, now that we're in this PPS regime. Because when you do that, you realise that, in a sense, putting aside all the technicalities, really registering is worthwhile just to avoid a fight. Previously, if a liquidator went into a company, they could obviously, if there's any goods there that have been supplied by trade creditors, they'd call up that trade creditor, come and get your goods. But if there's manufactured goods on site in a stock-in trade that the company has manufactured or put together, built or something like that, or there's commingled goods, the liquidators say, well, bad luck trade creditors, that's that now belongs to the company, and the liquidator could then sell those assets and use those funds to pay their fees and then make a distribution to unsecured creditors. Similarly with book debts, in the past, if there was book debts, if there were trade debtors, the liquidator could chase those debtors, recover those monies, use those monies to pay their fees and then make a distribution. Under the PPS world, if everyone registers their security interest, then what happens is that everyone becomes a secured creditor. So those commingled goods, those manufactured goods, the stock in trade in a company, the book debts themselves are all assets that are probably subject to the security interest, either through proceeds or through accessions or through commingled goods or whatever. So they're not available for the liquidator's fees. So it's really tough, in a sense, it's a tough world now for liquidators and insolvency practitioners to find assets in a company that they're dealing with to actually pay themselves and then make a distribution to an unsecured creditor. So it's not surprising then liquidators will take a fairly strict view in terms of whether they'll recognise security interests or not. And we saw this fairly early on when an example of this, fairly early on when the PPS Act started. There was a receivership up in Queensland of a business called Wow Sight and Sound. I don't know if any of you heard of that. It was a business like JB Hi-Fi. They sold all sorts of electronic equipment. The liquidator went in and a lot of this was just after the Act really commenced. A lot of, I suppose, those trade creditors, the suppliers to the business, hadn't got round to registering their security interests. If they'd thought about it, maybe they thought, oh, well, we've got a transitionary period where, or maybe even they got advice saying that, they've got a transitionary period, they've got 2 years to get their act in order. But the liquidator went in and basically said, any goods that have been supplied after the Act commenced, if you haven't registered, you're out. Really effectively undermined completely the transitionary provisions. And then really, I suppose, any trade creditors that put up a fight, maybe there was a bit of negotiation there. But the signal really was from the liquidator, if you haven't registered, I'm keeping the goods. So I think that's what I've seen happen again in subsequent liquidations. Liquidators have been taking a similar view. And it doesn't necessarily accord with the strict legal point of view, because the transitionary provisions are there obviously for a reason, and they're supposed to protect that sort of situation. But the practicalities is the liquidator can take that view, and unless the goods are worth enough to actually take on the liquidator, then you're going to be negotiating with the liquidator and losing your goods. So that's why registering is I think very important. So for instance, applying that to the landlord situation, maybe you look at the premises and go, oh no, everything's really a fixture, there aren't any goods, I don't have to worry. Now you might think that, but is it possible that a liquidator coming into the tenant might look at some goods and go, well, that's actually not a fixture, I can sell that. And so even if there is any doubt, you'd want to register just so that you don't have to have that fight with the liquidator when a liquidator is put in. So that's putting technicalities aside. We can debate all sorts of things about whether something's a fixture or not, but really for the cost of an $8 registration, it's worthwhile landlords doing that, I think. And then secondly, I'll talk about a coffee machine in a minute. Obviously then there's the flip side in terms of landlord registering. Is it worth, maybe actually when I was at the LPLC, I liaised with the LIV Leases Committee about drawing up these clauses, and one of the insights they gave me was about that time was a lot of the national tenants were sort of putting their foot down and really insisting that landlords don't register security interests over them, and using their commercial clout to say to landlords, no way, you're not registering, you're not messing up our credit rating by registering a security interest against us. And so there's a sort of obviously a commercial aspect to that. The landlord needs to consider, will registering over my tenant damage that commercial relationship? And also there's the potential overhead from a practical point of view, dealing then with requests for information or amendment demands. Is it really worth the bother? But I think that's from a practical point of view, that's the sort of considerations that you need to take into account. Moving on, the other aspect, I suppose, that I wanted to, when I was thinking about this, particularly uncollected goods, 2 minutes, oh gosh, I'm going to have to hurry. If you look at over the New Zealand experience, you're probably aware of the Portacom case, where a business that leased out goods, they were always the owner of the goods, they leased out the goods, their lessee, the lessee of the personal property, went into insolvency and they lost their portable buildings, valuable equipment. And you go, and we use this, or I used it at the LPLC, other people talk about it as well, to sort of scare people about, you better get onto the PPS. But I suppose looking at the flip side of that, the bank in that situation actually got a windfall gain, because they were given access to these portable buildings, which pre-PPS they wouldn't have ever got, to sell and to apply to the debt. So there are, whilst there are losses, there are people that can actually gain out of the PPS. So quickly, a hypothetical scenario, trying to make it practical. Imagine you've got a landlord who has a cafe or a premises, the tenant uses it as a cafe, tenant gets a coffee machine on loan and sends a bailment from a coffee company who says, if you buy my coffee, I'll give you this coffee machine. The lease comes to an end, the tenant leaves the coffee machine because then it's not mine, walks out, and then a liquidator is appointed to the tenant. Scenario that we've already talked about, what does the landlord do? It's an uncollected good. Do the landlord keep the coffee machine? I think from a practical point of view, pre-PPS, the landlord would make some inquiries and say, well, who does this coffee machine belong to? Ring up the coffee machine company, say, come and get your coffee machine. Post-PPS, pretty similar scenario, except that the landlord actually has somewhere to go to get information. They can search the PPS register. And that sort of resolves some of the problems that Sam was talking about in his second example of trying to get information from a liquidator and being fobbed off. So at least now the landlord has somewhere to go and search for security interests, and probably finds the coffee machine company as registered security interest, calls up the coffee machine company, says come and get your coffee machine. But what if the coffee machine company hasn't registered their security interest? Then there's a section of the Act says that if the tenant goes into liquidation, their security interest vests in the liquidator. So the coffee machine company have lost the coffee machine. Who gains it? Who gets that windfall gain? And that really can then depend upon what the lease says, whether the landlord's registered security interest, whether there are other security interests involved, and so forth. So I probably ran out of time. And there's two different scenarios. One, and I'll pick up this from the LPLC bulletin. Often a lease will say that a landlord gets to keep any property that's left by the tenant. Essentially, they just get this property as almost like a gift that the tenant gives them of uncollected goods. It's difficult to see how that gives rise to a security interest. It probably doesn't. But in that scenario of the landlord getting hold of this coffee machine, you then need to look at, okay, does the landlord take it free of other security interests? And you'd be then looking at the sections in the Act that talk about taking property free of other security interests. Probably not. It probably wouldn't fit into any of those categories. The alternative is the lease might say that the landlord can sell any property left by the tenant and apply those proceeds to reduce the tenant's indebtedness. It's a slight variation. That sounds a bit more like a security interest. And if then the landlord has registered that security interest and they're the highest ranking security interest, then they would get to keep the coffee machine. So maybe the landlord does get that windfall gain. Who knows?
I'll let Richard go over time there a little bit because I think some of that subject's very important, but you can ask questions after about that. I'm going to be fairly brief. You're probably already aware from what you've heard thus far that once a tenant puts something on premises, leased premises, and they become affixed to the land, that they become the landlord's property. Now, that position is the common law position. Victoria is the only state in Australia which has fundamentally changed the common law. Now, I have a little paper in there and you'll see what I'm about to talk about. Section 28(2) of the Landlord and Tenant Act fundamentally changed the common law. I've set out the provision there, you'll see that in clause 1. Basically, the provision says that there's a case called VOPAC, which the Court of Appeal said you interpreted according to its plain meaning. So while a tenant remains in possession of premises, things that have been affixed to the premises continue to be the tenant's property and are removable by the tenant during the tenancy or such further period of possession by the tenant holding the premises and not afterwards. So we're talking about any fixtures here, true fixtures or what's commonly called tenants fixtures. Tenants fixtures are things that are used in trade by tenants and traditionally have always been able to be taken away. I'm here talking about things that have been really affixed to the land, like machinery and what have you. The tenant is entitled to remove that equipment pursuant to 28(2) of the Landlord and Tenant Act. Obviously, it does say so that you can remove it so it's not going to injure the land, or if it does injure the land, you've got to rectify the problem that you've caused. So this fundamentally changed the common law. Now, it's interesting, while the section says that the property remains the property of the tenant, it doesn't say what happens to the property at the end of the lease period. In other words, once the tenant's gone, it's just assumed that the common law will then apply and the property will become the property of the landlord. And that's effectively what the Court of Appeal said in the case of VOPAC, which I refer to in there. It's a very important case. There's some very good paragraphs by Justice of Appeal Ormiston in there. So that is a very important provision. Now, it's been replaced by Section 154A of the Property Law Act, but the VOPAC reasoning will still apply. The Section 154A is not very well drafted, but it effectively means the same thing. I'm going to refer to another case too now called Commissioner of State Revenue and Unikema, and that case, the Court of Appeal held that the meaning of fixtures in Section 28(2) was to be given its broadest possible meaning. So it covered what I've referred to as tenants fixtures, and that, as I said before, that's trade fixtures, ornamental fixtures, or what you and I would call fixtures, that is things that are really affixed to the land. And the Court of Appeal there also held that it didn't just apply as between landlord and tenant. And the equipment here was heavy equipment, but comparatively easy to remove, and it was sold. The land was sold, and the Commissioner of State Revenue imposed duty on the purchaser, which included the assessed value of the plant and equipment, and the Court of Appeal said, no, you can't do that. The reason being that the value of the plant and equipment remained with the tenant and did not become part of the landlord's property to sell. You'll see in paragraph 4, I say there, the Commissioner argued that 28(2) only affected the relationship of landlord and tenant, but this was rejected by the Court. The effect of the section was that the landlord's rights with respect to the land were reduced as against all parties by the amount that the tenant's rights were increased. Now, I'm not going to read the quote, but it's worthwhile reading, okay? So what they're saying is the tenant's rights decreased the landlord's rights and anybody else's rights. So it's not just the landlord that's affected, it's third parties that might be affected. Those goods remain with the tenant. And it follows from that if the tenant mortgages chattels or goods and they actually become affixed in the true sense of the word, at common law, as I've said, they'd become the landlord's goods. But because of this act, their ownership remains with the tenant. So it seems to me that any security holder would be able to exercise rights against true fixtures, what the common law would call fixtures, during the period of the lease. So if the tenant defaults under its loan obligations, lending obligations, the mortgagee or security holder would be able to exercise rights against goods that the landlord might think are his goods, his or her goods, because they've actually become affixed to the land. Now, I haven't seen any cases on that point, but it seems to be logical. But the interesting question is how it would also relate to the PPSA, because as you've heard, the PPSA has no relevance to fixtures. So it may well be that the security holder is not going to succeed on any priority arguments. The PPSA won't apply, but just as a security document, just as a charge or whatever it is, they will be able to exercise their rights against the fixtures. But if there's any security fight, they might lose that. Now, I've had to deal with that fairly briefly. The other issue I was going to deal with is a recent case heard by Justice Gard. Now, you'll see I've referred to it in paragraph 9. I've actually got the heading around the wrong way. It should be Asian Pacific Building Corporation against Sharon Lee Holdings, and I've put it around the wrong way, but the actual citation is correct. Now, that concerned an appeal from VCAT. Now, many of you would be aware that distress for rent was abolished in 1948. Distress for rent is a common law concept. It enabled it doesn't depend on the wording of a lease. A landlord could go in, if a tenant failed to pay rent, and seize goods and sell those goods. But it was prohibited in 1948. It was abolished in 1948. What happened then is, as you've heard, the Landlord and Tenant Act was repealed, and that provision saying it had been abolished was in the Landlord and Tenant Act. But the repeal of the Landlord and Tenant Act hasn't led to the right to distress for rent arising again, and that's because of the way the Interpretation of Legislation Act works. And I've mentioned that in paragraph 10. So a landlord still can't use distress for rent. Justice Gard said, and this is on the second last page of the document, you'll see there, at common law, distress for rent was an incident of the right to a rent service and thereby an incident of the relationship of landlord and tenant. It arose automatically without the need for express agreement. Now, it could only be levied during the time the tenancy was subsisting and not after, and that's important for this case. So once a tenancy had been terminated, distress could not be levied, even for rent which had accrued before that date. Now, in this case, the landlord rented leased premises and forfeited the lease. Clause 8.1 of the lease, and it's set out there, but I'm going to have to read it. The lessor shall have maintained a lien on all the goods, chattels and equipment of the lessee in the premises, upon the lessee being in breach of its obligations under the lease. And the lessee agrees that the lessor may remove and retain the said goods, chattels and equipment until the lessee has paid the lessor all amounts of money owing to the lessor by the lessee. So the landlord retained the tenant's goods because rent hadn't been paid. In VCAT, the tenant contended that the seizure of the goods was unlawful and that the lien claimed by the landlord was unenforceable because it had the effect of granting the landlord a right to distress for rent. Now, that was successful in VCAT. The landlord's response was to say, look, distress for rent can only be levied during the subsistence of the tenancy, and because the lease had ended, that it's not relevant. And secondly, that the clause merely gave the landlord a right to a lien, which didn't come into effect until the landlord actually took possession. Now, the landlord was successful on appeal in front of Justice Gard. He overturned the tribunal's decision, and it's a useful case to read. His Honour said that distress for rent was seen by Parliament as an anachronism, but there was nothing to suggest that Parliament intended to limit the freedom of contract in other ways. And that the legislative purpose in abolishing distress for rent would be achieved without making the lien void. He said the lien wasn't expressed to empower the landlord to levy distress for rent, and importantly, the lien applied to all obligations under the lease and not merely to the obligation to pay rent. Remember, I said distress for rent only applies when rent hasn't been paid. Now, also, the lien could be confined in its operation to the period after termination of the tenancy, even though it was expressed much more broadly than that, and that it didn't empower the sale of any goods, which would be the case if it was implementing distress for rent. So if you draft one of these clauses in your leases, avoid a right for a landlord to go in during the term of the tenancy and seize and sell goods. Make sure that any clause you have applies after the lease ends and enables, if you can sell goods after the lease ends, that won't be caught. That's really all I have time to say. I'm afraid it was a bit quick, but we'll now have some questions.
Just a comment on the lien in the Sharon Lee Holdings case. The court held in that case that a landlord had a lien over the chattels that were left behind, and he could apply that both to rent and to any other obligations that were unpaid under the lease. Most leases will have an abandonment clause, and generally speaking, they're effective. So if goods are left behind, they're deemed, after a reasonable period of time, they're deemed to be abandoned, and title vests in the landlord. Under an abandonment clause, you get the goods free of charge. The lien can only be used presumably to sell the goods and apply them to the arrears that you have, which means any damages claim or debt claim that you have against the tenant, if you choose to sue them down the track, must be reduced by the value of those goods if you exercise the lien. I'm generally telling landlords to put the lien into their leases because it's better to have it than not to have it in the event that you sell the tenant's goods. But you're also better off having an abandonment clause, because under the abandonment clause, the goods are yours, free of charge, and your debt claim is unaffected if you ultimately sue the tenant. Or, as often happens when you've got an abandonment or a termination, your tenant might come after you afterwards for a damages claim, and you can use that debt claim as a set-off. So the lien, I think, is a really useful thing to add to the document. It's good to have there if you're acting for a landlord. Better to have it than not to have it, but the abandonment clause remains far more, a more useful and a preferable tool. So make sure you've got both of them in your lease.
Well, that raises straight away the question, though. I think Richard mentioned that he did not think that an abandonment clause would be caught by the PPSA. It was not a security interest because it's not in substance security for an obligation. Now, I agree with that, but what I was going to ask Richard about is what about the possessory lien point?
Yeah, I was thinking about that actually when you're talking. There is a carve-out in the Act, Section 8, talks about interests to which this Act doesn't apply, and it has 8B is a lien essentially created by a law of the Commonwealth, so it's sort of a statutory lien. I don't think that applies. And then 8C is a lien that is provided for under the operation of the general law. Now, this is a lien really that it's a contractual lien, so I don't know whether that would cover it or not. Again, I would say if you've got a lien, you'd register a security interest so you don't have a fight with a liquidator, because the last thing you want is the liquidator to come in and say, yes, you've got a lien, but that's a security interest that is covered by the Act. You haven't registered it, and so it vests in me, so your lien is ineffective. So I don't know. I can't say definitively whether it is a security interest or not, but I would say, register a security interest anyway.
I'm perhaps showing my ignorance here. How do you actually register the security interest over an item that you don't know is going to be subject of the lien? I mean, at the point in time the lien, when you enter your contract, you don't know over what the lien might or might not apply.
Yeah. All you do is you're registering a security interest against the grantor, so against the tenant's name, and then all you have to select various things about whether it's commercial property, whether it's inventory and so forth. And the main thing then you select is the collateral type, and in this case it'd just be other goods. You don't even have, you can put a description of the other goods, you don't have to, but essentially all you're saying, putting on the register, is that you've got a security interest in this grantor over other goods, and the security interest arises when the lease is entered into, and if you register, you get the priority when you register. It may, obviously the lien will only attach when the goods are actually abandoned, but that doesn't prevent you from registering up front.
Isn't it the same as a floating charge at that point?
Yeah, essentially, yeah.
I actually have another question. It's not really to do with, it's to do with tenants' obligations. What about the situation where, as happens on most leases, where tenants have to provide a bank guarantee to secure their obligations under the lease, or a security bond, or even cash? Those are the sort of things a landlord should be registering?
It's a really difficult question, and I don't really want to answer it because it's so complicated. I think the LPLC bulletin, I'll just rely upon them, they say that it only applies if a cash security deposit is given. That does create a security interest.
From what you were saying earlier, you might as well just register anyway, willy-nilly.
Yeah, I think really there's not a lot of downside in registering. I think some people might be concerned, what if you're registering and you don't really actually have a security interest? What are the liabilities attaching there? I think, look, the register is full of erroneous registrations. I haven't seen anyone prosecuted for that. I don't think I would be very surprised if anyone was prosecuted for that. In terms of removing registrations, interestingly, for commercial property as opposed to consumer property, let's say you register, a trade supplier, and you've got a customer come along and you register a security interest over that customer. There is nothing under the Act that says that you actually have to remove that security interest when the customer comes to you and says, I'm not going to buy your goods anymore. There is actually no obligation under the Act to remove it. The explanatory memorandum explains and says, well, there's no need to have it there because the amendment demand process is there for that purpose. So I don't see a big downside in registering.
Thank you. Now, James didn't, there was a lot in James's paper that we didn't get to deal with. He did mention that the Australian Consumer Law and Fair Trading Act now had a substantial series of provisions concerning uncollected goods. Now, the law, the parliamentary draftsman has assumed that the relationship of a landlord and a tenant after the tenant leaves and goods are left behind is that of bailor and bailee. I was going to ask James if he thinks that's going to cause any problems, because there's no real definition of bailee that's helpful.
Yes, that is a factor. There's nothing in the Part 4.2 that deals specifically with whether or not landlord and tenant situations are covered by the legislation. The legislation simply adopts this concept of bailment and then applies to any bailment situation. So that really begs the question of what is a bailment in a landlord and tenant context. There's been clear authority that where there's a re-entry by the landlord and the landlord takes possession of the premises and possession of the goods, that there'll be at least a gratuitous bailment that arises in that circumstance. There's a more difficult question though when the lease simply expires and goods are left on the premises at that point. I think there's been a paper previously drawn by Robert Hay that says that a bailment must normally be a voluntary relationship where custody of the goods is handed over and accepted willingly by the bailee. So in circumstances where the landlord's just lumped with the goods effectively because they're left there, there's a question of whether any bailment can arise, and therefore a question in that circumstance of whether all of these new provisions in Part 4.2 even apply.
Parliament's likely VCAT's likely to find they do, but there are other issues in this new legislation, aren't there? It has different categories of goods in terms of value of the goods, like it's got a regime for a landlord dealing with goods worth less than $200, between $200 and $5,000, and goods over $5,000. And I was going to ask James whether in coming up with those values, well, firstly, how do you go about valuing? Does the Act say anything about that? And secondly, do you bundle goods left behind together, or should each thing be valued separately?
Well, I think the last point is perhaps the more important. There's nothing in the Act to actually define what goods means. And given that you have these values that decide how the goods are to be treated, there's three categories. There's low value goods, which are between $0 and $200, then medium value goods between $200 and $5,000, and then high value goods above that amount. And so because you're dealing with those three categories, you have to put some value on the goods. The first question is, are the goods treated individually or are they valued in bulk? And there's no real answer to that. I suppose that consistently with the purpose of the legislation, you might say that it's there to allow someone who's in this situation, particularly a landlord in this case, to dispose of the goods in their entirety and rid themselves of the problem at hand. And so therefore the goods would encompass all of the goods that are left on site collectively, but that's not something that's been decided at this point. As to the second question of how the value is actually ascertained, again, there's nothing in the Act about that. I suppose that the landlord would just have to do their best and perhaps obtain some kind of evidence from a second-hand goods dealer or somebody else with knowledge of the value of those goods to determine which category they fall within, because particularly in terms of the medium versus the high value categories, there are quite substantial differences between the processes that apply depending on what those goods are valued at and which category they fall into. So it's important to ascertain that value correctly to know what your obligations are.
There are substantial, each category of goods has a time frame that applies before you can engage the process of trying to get rid of the goods. Is there any way in the Act of short-circuiting those time frames?
Well, again, there's no cases, I should add, so all of this is really just a matter of statutory construction, nothing whatsoever on the new statute, but there is a right to apply to VCAT to seek orders generally in relation to the sale. I'd anticipate that there will be applications of that nature made in the future where a landlord is saying it's simply too onerous to wait the time limit, and so therefore I want to have that time limit shortened by a tribunal order. And I do note as well the time limits have been extended, so in relation to valuable goods or high value goods, you have to wait 180 days before disposing in accordance with Part 4.2. So they're very onerous conditions. You have to store the goods and potentially insure them as a bailee in that time, and it can create very significant issues.
Can you contract out of the regime?
It is subject to what the parties agree in the lease, and as I said before, there's a express preservation of the common law in Part 4.2, so things like abandonment clauses and the general rights that Sam's referred to before that a landlord has once an abandonment clause kicks in are still preserved, and including the right of freedom of contract, which was discussed in the Shah Ali case before. All those rights are still available.
I would suggest that anyone drafting a lease should have an abandonment clause, because you don't want to have to go through this rather torturous regime where the landlord's got to store the goods and insure the goods, and you know, it's quite a onerous regime. You mentioned, and I mentioned too, that the Landlord and Tenant Act provisions concerning uncollected goods had been repealed. Do they still apply to any leases?
Yes, I believe it's 1st of September 2012 is the changeover date, and there's a Schedule 4 that's in the the Australian Consumer Law and Fair Trading Act, which says that any leases that were in force as at 1st of September 2012 still remain covered by the old legislation. The old legislation's under the Landlord and Tenant Act, it's Part 4A. It's in fairly similar terms, which are easy to ascertain if you read the Act. The timeframes are a bit shorter, but otherwise it's quite similar.
All right, would anyone like to ask questions? Yes?
Can I ask one, please, just going back to bank guarantees?
Yes.
I can understand the situation with the security deposit in cash, but isn't a bank guarantee a relationship between the landlord and the bank? And in that circumstance, where does the PPS come in?
I think Richard was actually suggesting that was the case.
Yeah, look, you could debate that, and people have debated it for ages. I don't know the answer. And I don't think really anyone knows the answer until a case is decided on that point. But yeah, look, it is a big issue, and if you're in doubt, then you'd register a security interest to protect.
I should say the point you're making, I think, is a good one, though. As you say, the tenant purchases the bank guarantee effectively, and it's the bank that's providing the guarantee. So logically, it wouldn't be caught by the PPSA. I would think that's the case.
I don't think it's purchase. I think the bank has probably got security over the tenant's assets, which creates another differential. and therefore, if the bank had security, it would be able to enforce its rights to that guarantee over those assets, and that distances again, I think, the landlord.
But the important point must be it's the bank's money ultimately that's drawn down. Any other questions? All right, well, thank you for... Oh, there's one over there. Yeah.
We've got a current situation now where landlords actually re-enter the premises. The landlord wants to know whether she can actually go in and continue running the business, and whether there's any dangers that lie in it.
Well, there's nothing stopping a landlord... I mean, I don't want to be giving advice, but there's nothing stopping a landlord running it. You see, you've got to be careful here. It might be that there's not... If you've got to look at the terms of the lease, it might not be an actual termination of the lease if you do that too. You actually have to look at the provisions, because there are cases where tenants have struggled and landlords have gone in to run businesses, and that has not meant that the lease has been ended. But if you've actually terminated the lease, it has actually been terminated and the landlord's gone in and is running a business, it's effectively a new business. But the assets will still be some of the assets, the physical assets, will still be the tenants, and you'll run into problems, I think, unless you sort all that out. You're better to close the business down completely and deal with the physical assets, and if the landlord wants to start another business, they can do so. Any other questions? All right, well, thank you very much for coming. Hope we see you again. Thank you.
And just as a parting comment, if anyone knows where I can find a valuer who can determine the market value of a unicorn, please let me know.